Good afternoon, members of the Board of Directors. My name is Gerald Smith, and as you know, I'm currently the Chief Ethics and Compliance Officer for your company. Today, I'm going to provide you with a presentation that details the reasons why appointing an independent Chief Ethics and Compliance Officer who reports directly to the Board of Directors is critical to implementing an effective compliance program and ensuring board oversight responsibility. This is an overview of my presentation, which includes the Board of Directors' oversight responsibility with regards to the federal sentencing guidelines and the Caremark fiduciary duty. To better understand the Board of Directors' oversight responsibility of the Compliance and Ethics Program, my presentation will include a summary, the consequences, and reasons for General Motors and Volkswagen compliance failures. Also, my presentation will discuss the benefits of appointing an independent Chief Ethics and Compliance Officer, the qualifications, skills, and responsibilities of the Chief Compliance and Ethics Officer, the legal guidance which supports the position being independent, and the best practice in the auto industry. Even though all companies in the auto industry have a compliance and ethics program and a chief compliance officer or a chief ethics and compliance officer appointed, several auto companies did not have an effective compliance program due to the board of directors at General Motors and Volkswagen not being aware of compliance violations, which resulted in criminal charges, criminal and civil fines, lawsuits, the need to have an independent compliance monitor appointed, and harm to reputation. The lack of awareness by the board of directors was due to a conflict of interest with legal counsel and management, and not having the chief ethics compliance officer report directly to the board of directors. Appointing an independent chief ethics compliance officer who reports directly to the board of directors would improve the board of directors' federal sentencing guidelines and Caremark fiduciary oversight responsibilities, because it will increase the likelihood that the board of directors are aware of compliance violations, ensure the board of directors receive timely, independent, and unbiased information, create a more effective compliance and ethics program, improve safety, reduce the possibility of criminal charges, criminal and civil fines, lawsuits, need to have an independent monitor appointed, and harm to reputation. For a compliance and ethics program to be considered effective, the federal sentencing guidelines requires the board of directors to be knowledgeable about the content and operation of the compliance and ethics program and exercise reasonable oversight with respect to the implementation and effectiveness of the compliance and ethics program. Because the federal sentencing guidelines have 7 essential elements for a compliance and ethics program to be considered effective, the board of directors needs to ensure that they have oversight of all 7 elements, which will be discussed later in the presentation. In addition to the board of directors being knowledgeable and providing oversight of the compliance and ethics program, the federal sentencing guideline states that to have an effective compliance program, a high-level individual, such as a director, must promote an organizational culture that encourages ethical conduct and a commitment to compliance with the law. Because promoting an ethical culture is critical to an effective compliance program, and the board of directors have oversight responsibility of the implementation and effectiveness of the compliance and ethics program, it's critical that the board of directors ensure the organization is promoting an organizational culture, which can be best done by having the chief ethics and compliance officer report directly to the board of directors. Additionally, the chief ethics and compliance officer should report directly to the board of directors based on the federal sentencing guidelines, which states that the individual who is delegated day-to-day operational responsibility for the compliance and ethics program shall report periodically to the governing authority or an appropriate subgroup of the governing authority on the effectiveness of the compliance and ethics program, and to carry out such operational responsibility, such individuals shall be given appropriate authority and direct access to the governing authority or an appropriate subgroup of the governing authority. It's critical for the board of directors to ensure that an organization has an effective and compliance ethics program because the federal sentencing guidelines considers an effective program a mitigating factor when deciding the ultimate punishment of the organization. Additionally, an effective compliance program is critical because the Department of Justice, when considering whether to bring charges, considers the adequacy and effectiveness of the corporation's compliance program at the time of the offense. Also, if an organization has an effective compliance program, the DOJ will most likely not impose liability upon a corporation, particularly one with a robust compliance program in place, for the single isolated act of a rogue employee. By having a robust compliance program in place, the board of directors can mitigate the risk of a rogue employee simply by having an effective compliance program in place. In addition to the federal sentencing guidelines oversight responsibilities, the board of directors have the Caremark fiduciary oversight responsibility that requires the board of directors to implement a board-level information and reporting system that is reasonably designed to provide the board itself timely, accurate information sufficient to allow the board to reach informed judgments concerning both the corporation's compliance with law and its business performance. If the board fails to have any information and reporting system, it may render a director liable for losses caused by non-compliance with applicable legal standards. Additionally, the board of directors may be liable if they are alerted to red flags of misconduct and took no steps in good faith effort to prevent or remedy that situation. The appointment of an independent Chief Ethics and Compliance Officer would ensure that the board of directors receive timely, independent, and unbiased information, which would allow the board of directors to take immediate action to reduce risk to the organization. After I provide a summary and the consequences of GM's and VW's compliance failures, on the next few slides I will also provide the reasons for their failures which could have been prevented if GM and VW had an effective compliance and ethics program that promoted an ethical culture and a commitment to compliance with the law. In 2002, GM could have prevented a catastrophic safety defect if they would have complied with the 2002 National Highway Traffic Safety Administration regulation, which required auto companies to report safety defects within 5 days after the manufacturer determines that its product contains a safety-related defect or non-compliance. Rather than report the safety defect to the National Highway Traffic Safety Administration within 5 days, GM engineers who knew before the defective switch even went into production in 2002 that it was prone to easy movement out of the run position and that testing fell below GM's own internal specification, approved its production anyway. Even after customers in 2004 and 2005 began experiencing sudden stalls and engine shutoffs caused by the defective switch, engineers responsible for decision-making on the issue opted to leave the defective switch as it was and simply promulgate an advisory to dealerships with tips on how to minimize the risk of unexpected movement out of the run position. GM even rejected a simple improvement to the head of the key that would have significantly reduced unexpected shutoffs at a price of less than $1 a car. At the same time, in June 2005, GM made public statements that, while acknowledging the existence of the defective switch, gave assurance that the defect did not pose a safety concern. In 2012, GM investigating engineers, certain supervisors, and attorneys at GM learned that the safety defect could cause airbag non-deployment in certain GM cars. Even though the seriousness of the safety defect was determined in 2012, GM did not notify the public or the National Highway Traffic Safety Administration until approximately 20 months later in February 2014, and also failed to correct its June 2005 assurance that the defective switch posed no safety concern. The delay in disclosing the defect was due to employees wanting to find a solution for the defect and internal investigators keeping the airbag non-deployment caused by the defective switch offline, outside of GM's regular recall process. In 2015, the Department of Justice criminally charged GM with concealing a potentially deadly safety defect from the National Highway Traffic Safety Administration from the spring of 2012 through February 2014, and in the process misleading consumers. As part of a deferred prosecution agreement, General Motors admitted that it failed to disclose a safety defect to the National Highway Traffic Safety Administration and misled U.S. consumers about that same defect, and acknowledged a total of 15 deaths as well as a number of serious injuries caused by the defective switch. Additionally, as part of the deferred prosecution agreement, General Motors agreed to have an independent monitor to review and assess policies, practices, and procedures relating to GM safety-related public statements, sharing of engineering data, and recall processes, and agreed to transfer $900 million for parallel civil action. If GM abides by all the terms of the deferred prosecution agreement, the Department of Justice will defer prosecution for 3 years and then seek to dismiss the charges. The first reason for GM's compliance failure was due to non-compliance with regulations, standards, and policies, which included the failure to follow the National Highway Traffic Safety Administration's 5-day safety defect reporting rule, the failure to follow a regular recall process, and the failure to establish and monitor internal controls. Based on the pervasive misconduct that occurred at GM, the second reason for GM's compliance failure was due to the lack of a strong ethical culture. Additionally, due to the board of directors at General Motors not being aware of the safety defect until December 2013, it appears that GM did not have a strong safety culture, as unawareness at the top would be impossible in an organization with a strong safety culture. Additionally, GM may have not had a safety culture because the single most important attribute for a company with a strong safety culture is having a proactive and timely voice related to failures. It's critical for companies to encourage employees to speak up, because this willingness to speak up is especially true for the small and seemingly inconsequential discrepancies that can, when unreported, give rise to catastrophic failures later. Any organization can detect big, expensive failures. It's the great companies that detect the small ones that otherwise go unnoticed. The third reason for GM's compliance failures was due to the lack of awareness by the board of directors, as GM's board of directors on the issue of vehicle safety took a mostly hands-off approach, rarely even discussing the topic beyond periodic reviews of product quality with company executives. Because General Motors board of directors took a mostly hands-off approach, it's not surprising that based on the board of directors' caremark fiduciary duty and General Motors board not being aware of the safety defect, several lawsuits were filed by GM shareholders against current and former board members for failing to exercise their fiduciary duty. Based on the legal language in one of the lawsuits, which claimed board members are guilty of sustained and systematic failure to keep informed of safety and recall issues, they set up a system that is calculated not to inform them about safety issues. I believe GM could have prevented the safety defect if they would have had an independent chief ethics and compliance officer reporting directly to the board of directors. An independent chief ethics and compliance officer would have ensured that the board received timely and accurate information, which would have enabled the board to reach informed judgments concerning both the corporation's compliance with law and its business performance. Because employees are more likely to follow policies, rules, and regulations in organizations that have a strong ethical culture, GM could have prevented the non-compliance with regulations, standards, and policies if they would have promoted a strong ethical, safety, and speak-up culture. Because GM cited cost as one of the reasons for not fixing the problem, it appears GM's culture focused on cost rather than safety, as GM could have significantly reduced the risk of this deadly defect by improving the key design for less than $1 per vehicle, but GM chose not to because of the cost. If GM would have had an independent chief ethics and compliance officer that reported directly to the board of directors and required employees in their code of conduct or ethics to report safety violations, GM would have been in compliance with the National Highway Traffic Safety Administration's 5-day reporting rule. As you can see from the images on the slide, which are from GM's current code of conduct, GM is certainly promoting an ethical, safety, and speak-up culture. VW could have prevented criminal charges, billions of dollars in criminal and civil fines, the need to have an independent corporate monitor appointment, and harm to reputation if they would have complied with the newer and stricter EPA Clean Air Act and California Air Resources Board emission standards. The reason for VW's non-compliance was due to VW's engineers who, after realizing in 2006 that they could not design a diesel engine that would meet the stricter emission standards, deciding to design a software function with senior management approval to cheat US emission tests. After years of selling the diesel cars in the United States, a 2014 West Virginia University study identified substantial discrepancies in the emissions from certain VW vehicles when tested on the road versus when undergoing EPA and CARB standard drive cycle test. After the EPA and CARB questioned the testing discrepancies, VW employees provided the EPA and CARB with testing results, data, presentations, and statements to make it appear that there were innocent mechanical and technological problems to blame, while secretly knowing that the primary reason for the discrepancy was their cheating software that was installed in every VW diesel vehicle sold in the United States. VW employees continued the back and forth with the EPA and CARB for over 18 months, obstructing regulators' attempts to uncover the truth. After nearly 2 years of stonewalling investigators, VW admitted in September 2015 that it had installed defeat devices in millions of its diesel-powered cars. In January 2017, VW agreed to plead guilty to 3 criminal felony counts and pay a $2.8 billion criminal penalty as a result of the company using a defeat device to cheat on emission tests and lying and obstructing justice to further the scheme. In addition to the criminal penalty, VW agreed to pay $1.45 billion to resolve EPA's civil penalty claims and the U.S. Customs and Border Protection claims for customs fraud. Also, as part of the plea agreement, VW was required to have an independent corporate compliance monitor who will oversee the company for at least 3 years. Also on the same day of VW's guilty plea, a federal grand jury indicted 6 VW executives and employees for their roles in the nearly 10-year conspiracy. The total price tag on non-compliance for VW was 32 billion euro or 37 billion US dollars in fines, penalties, and compensation to customers. In addition to financial costs, the harm to reputation caused VW's brand to plunge after the scandal, which led to VW announcing in 2016 it would eliminate 30,000 jobs worldwide as it overhauled operations in the wake of the scandal. The first reason for VW's compliance failure was due to non-compliance with laws and regulations, which included violating the EPA's Clean Air Act and CARB emission standards by selling 590,000 diesel cars that emitted pollution up to 40 times higher than U.S. emission standards, obstruction of justice for destroying documents, and violating the U.S. Customs and Border Protection law for knowingly submitting false statements and omitting material information for each of the nearly 590,000 imported vehicles. Based on the pervasiveness of the misconduct that occurred at VW, the second reason for VW's compliance failure was due to the lack of a strong ethical culture. Additionally, it appears that VW's board of directors were unaware of the non-compliance and did not promote a speak-up culture, as numerous employees were aware of the misconduct and failed to report it. Because employees are more likely to follow policies, rules, and regulations in organizations that have a strong ethical culture, VW could have prevented the non-compliance with regulations and laws if they would have promoted a strong ethical and speak-up culture. Because GM's and VW's compliance failures were due to an ineffective compliance and ethics program, and the federal sentencing guidelines for a compliance program to be considered effective requires the board of directors to be knowledgeable about the content and operation of a compliance and ethics program and exercise reasonable oversight with respect to the implementation and effectiveness of the compliance and ethics program. It's critical that the board of directors be knowledgeable about the implementation and effectiveness of the federal sentencing guidelines' 7 essential elements. The best way for the board of directors to be knowledgeable and exercise oversight of each essential element is for the chief ethics and compliance officer, who has the day-to-day operational responsibility for the compliance and ethics program, to report directly to the board of directors. By having the chief ethics and compliance officer report directly to the board of directors, the board will ensure that each of the 7 essential elements are being implemented effectively. It's critical for the board of directors to ensure that each element is being implemented effectively, because in addition to an effective compliance program being a mitigating factor in the ultimate punishment of the organization and a factor in whether the DOJ brings charges, the 7 essential elements will reduce safety incidents, the possibility of criminal charges, criminal and civil fines, lawsuits, the need to have an independent monitor appointed, and harm to reputation. By providing oversight and ensuring that the first element of standards and procedures is being implemented effectively, the board of directors will ensure that the organization has effective standards, procedures, and internal controls that are designed to prevent and detect misconduct, which includes preventing violations of laws applicable to the auto industry, such as the National Highway Traffic Safety Administration's 5-day safety reporting rule and the EPA's and CARB stricter emission standards. Additionally, board of director oversight of the first element ensures that the organization's policies, such as the code of conduct, has clear standards that states the organization's commitment to an ethical culture. By providing oversight of the second element, compliance high-level oversight, the board of directors will ensure that the chief ethics and compliance officer has sufficient resources, authority, autonomy, and support from the board of directors. Both authority and autonomy are critical because it achieves the 5 principles of an effective chief ethics and compliance officer, which include empowerment, which gives the chief ethics and compliance officer the ability to carry out their duties; independence, which allows the chief ethics and compliance officer to be objective and provide the board of directors with unbiased info and prevents conflict of interest with legal and undue influence from management; seat at the table, which gives the chief ethics and compliance officer the ability to collaborate on strategic and risk management decisions with other senior managers; line of sight, which allows the chief ethics and compliance officer to see and be seen, have access to staff, and unfettered access to relevant information; resources, which ensures the chief ethics and compliance officer has sufficient staff and budget to implement an effective compliance and ethics program. By providing oversight of the third element, education, communications, and training, the board of directors will be ensuring that training is effectively preventing and detecting misconduct, promoting an ethical culture, and educating employees on policies and procedures such as safety requirements to prevent injury. Additionally, oversight of training will ensure that training is being updated and tailored to effectively mitigate risks. By providing oversight of the fourth element, auditing and monitoring, the board of directors will be ensuring that they are knowledgeable about the overall implementation and effectiveness of the compliance and ethics program, as an audit will provide the board of directors with an independent and objective assurance that the compliance and ethics program is effective. The oversight of monitoring will ensure that organizational risks are being identified through a risk assessment, and standards, procedures, and internal controls are updated to mitigate risks. Because the federal sentencing guidelines requires an organization to periodically assess risks and take appropriate steps to reduce risk, the board of directors, through their oversight, should ensure that risk assessments are conducted annually. By providing oversight of the fifth element of reporting, investigation, and background checks, the board of directors will ensure that they are informed of hotline complaints, that investigations are being properly conducted, and that background checks of employees and vendors are being conducted to mitigate potential risks of harm to the organization. Based on the caremark fiduciary duty, it's critical that the board of directors be knowledgeable about hotline complaints and ensure that they are properly investigated, because the failure to investigate signs of wrongdoing, such as red flags, is considered failing to act in good faith and a breach of the board of directors' duty of oversight. If investigations are not properly investigated, internal complaints can become external complaints and cause harm to the organization's reputation. Because the False Claim Act and now the Dodd-Frank Act provides financial incentives for whistleblowers, the risk of external complaints is high. The appointment of an independent chief ethics and compliance officer who reports directly to the board of directors is the only way to ensure that complaints are independently and objectively investigated and minimize the risk of external complaints. Also, by ensuring that complaints are being independently and objectively investigated, the board of directors will be promoting a speak-up culture that encourages employees to report misconduct without fear of retaliation. By promoting a speak-up culture, unethical behavior such as fraud is much more likely to be prevented and detected, because the number one reason for detecting fraud is due to tips. By providing oversight of the sixth element of enforcement and discipline, the board of directors will ensure that the organization has clear disciplinary procedures in place and are enforced consistently. Based on the three elements of the fraud triangle, enforcement and discipline are critical, because when policies are not enforced, opportunists get the message that they too can engage in wrongdoing without consequences. Additionally, if policies are not enforced, employees are not likely to report a violation if they think nothing will be done. Also, it's important that the board of directors ensure disciplinary actions are fairly and consistently applied across the organization, because a sense of inconsistency and a lack of fairness are risk factors that can lead to unethical behavior. When an organization applies discipline fairly and consistently, the organization will build a climate of trust. Without trust, employees will be out for themselves, which can lead to rationalized unethical conduct as a survival mechanism in the organization. Because disciplinary measures significantly impact the culture of a company and individual behavior, and a company cannot achieve compliance without first addressing behavioral issues in its culture, it's critical that the board of directors embed accountability into the culture of the organization. By providing oversight of the seventh element of response and prevention, the board of directors will be ensuring that the organization meets the federal sentencing guidelines, which requires an organization, after criminal conduct has been detected, to take reasonable steps to respond appropriately to the criminal conduct, to prevent similar criminal conduct, including any necessary modifications to the organization's compliance and ethics program. By providing oversight and ensuring remedial actions have been taken, the board of directors can significantly reduce the risk to the organization, because DOJ prosecutors, when considering whether to charge an organization, considers the corporation's remedial actions, including but not limited to any efforts to implement an adequate and effective corporate compliance program or to prove an existing one. Because a company cannot achieve compliance without first addressing behavioral issues, and the tone from the top is what establishes the culture of the organization and influences individual behavior, my next slide discusses the critical importance of the board of directors creating and promoting an ethical culture. Because both General Motors and Volkswagen's compliance failures were also due to a lack of an ethical culture, and the federal sentencing guidelines requires a high-level individual to promote an ethical culture, it would be beneficial for the board of directors to have the chief ethics and compliance officer report directly to the board of directors, so that the board of directors can ensure the organization is promoting an organizational culture that encourages ethical conduct and a commitment to compliance with the law. Due to the culture of the organization being determined by the tone from the top, the board of directors play the most important role in determining the culture of the organization. Because employees are more likely to follow policies, rules, and regulations in organizations that have a strong ethical culture, and research has shown that culture has a greater impact than a formal ethics and compliance program on outcomes such as observed misconduct, reporting of misconduct, it's critical that the board of directors create an ethical culture through tone from the top. In addition to the tone from the top being established by the board of directors in the code of conduct, the board of directors can also demonstrate their tone and their commitment to an ethical culture through their actions. By appointing an independent Chief Ethics and Compliance Officer, the Board of Directors would be demonstrating their commitment to an ethical culture and also be setting the tone for the organization that both compliance and ethics are to be taken seriously. The high visibility of the Chief Ethics and Compliance Officer position would ensure that all employees, including senior executives and managers, are taking compliance and ethics seriously in their decision making. The Board of Directors' tone from the top is important for many reasons, which include fewer employees feeling pressure to commit misconduct, employees willing to report misconduct, and less retaliation. A major factor in an employee's decision to act ethically is whether or not the anticipated action is deemed acceptable in the corporate culture, and employees look to immediate supervisors for signs that the tone at the top is important and is taken seriously. Because tone from the top determines the culture of the organization, and culture is one of the most important factors in determining how employees behave, it's critical that the Board of Directors work closely with the Chief Ethics and Compliance Officer to ensure that the Board of Directors' tone from the top is being effectively communicated throughout the organization on a continual basis. By appointing an independent Chief Ethics and Compliance Officer, the Board of Directors can eliminate potential failures that can occur in the 3 lines of defense risk management model, which is shown here. Even though the first line of defense, management controls and internal control measures, reduces inherent risk to the organization, the first line of defense is the least independent and objective of the line of defenses because either the managers with the day-to-day oversight or senior management could override or ignore them. In addition to overriding controls, management may even fail to implement internal controls, which may have been the case at General Motors. If GM management would have had internal controls in place for notification of safety defects, perhaps management would have been alerted to the non-compliance versus the engineer in charge of the defective switch approving its production anyway. Additionally, if Volkswagen had internal controls in place to ensure compliance with the EPA Clean Air Act and the California Air Resources Board emission standards, perhaps the second line of defense would have been alerted to the non-compliance versus engineers with management approval designing the software function to cheat U.S. emission tests. Because all the second line defenses to include compliance are subject to senior management influence and do not report to the Board of Directors, the second line of defense is not considered the strongest defense. Even though the second line of defense does not report to the Board of Directors, their assessments are critical based on the caremark fiduciary duty. Even though it appears GM did not have a first line of defense with regard to the safety defect, they did have a second line of defense, but it failed because after GM investigating engineers, certain supervisors, and attorneys at GM learned in 2012 that the safety defect could cause airbag non-deployment in certain GM cars, GM did not notify the public or the National Highway Traffic Safety Administration until approximately 20 months later. Because internal auditors, as the third line of defense, provide independent and objective assurances about the design and the effectiveness of the first and second line to both senior management and the board, they are considered the most independent and objective of the 3 lines of defense. Based on the compliance officer being in a strategic role in conducting risk assessments, which are a comprehensive evaluation of a company's risks, including legal, financial, and reputational, the compliance officer position should be moved to the third line of defense to ensure that the Board of Directors receive timely, objective, and accurate information. The benefits of the Board of Directors receiving more timely, objective, and accurate information would better enable the Board of Directors to quickly resolve non-compliance with laws and regulations and prevent safety defects from potentially causing death and injuries. Also, by receiving timely, objective, and accurate information, the Board of Directors will better meet their caremark fiduciary duty and be better enabled to resolve problems internally, which will prevent external complaints. Additionally, by moving the Chief Ethics and Compliance Officer to the third line of defense, the Board of Directors will be providing effective oversight of the 7 essential elements by ensuring that the Chief Ethics and Compliance Officer implements internal controls for new laws or regulations. Based on the Chief Ethics and Compliance Officer's education and training, skills and responsibilities closely aligning with the Board of Directors' oversight responsibilities, such as ensuring that risk management policies and procedures and codes of conduct and ethics should be incorporated into the company's strategy and business operations, with appropriate supplementary training for employees and regular compliance assessments, the appointment of an independent Chief Ethics and Compliance Officer would better ensure that the Board of Directors' oversight responsibilities are being implemented effectively. In addition to the Chief Ethics and Compliance Officer having the qualifications, which includes having at least a bachelor's degree in business management or business administration, law, or finance to be an independent Chief Ethics and Compliance Officer, the Chief Ethics and Compliance Officer's training is closely related to the Board of Directors' risk oversight responsibility, as their training consists of working in roles that offer them experience in risk management. The skills that are closely related to the Board of Directors' risk oversight responsibility include the Chief Ethics and Compliance Officers assessing business or industry specific risks and to establish internal controls to minimize exposure. Additionally, the Chief Ethics and Compliance Officer is well qualified for an independent position based on their strong communication and problem-solving skills, integrity, and attention to detail. Based on many of the Chief Ethics and Compliance Officer's responsibilities directly relating to the 7 essential elements of an effective compliance and ethics program, to include promoting an ethical culture, and the federal sentencing guidelines requiring the Board of Directors to be knowledgeable about the content and operation of the compliance and ethics program and exercise reasonable oversight with respect to the implementation and effectiveness of the compliance and ethics program, it would be beneficial for the Board of Directors to appoint an independent Chief Ethics and Compliance Officer so that the Chief Ethics and Compliance Officer has the authority and autonomy needed to meet the responsibilities, which include ensuring effectiveness of the 7 elements of a compliance and ethics program, ensuring laws and regulations are incorporated into policies, processes, and training, updating policies such as the Code of Conduct, internal control procedures, and training to mitigate risk, ensuring all employees receive general and specific training, promoting an ethical and speak-up culture by conducting annual employee surveys, and providing staff with ongoing communication which promotes an ethical culture, ensuring timely, proper investigations, and they may also be part of an investigation team, conducting annual risk assessments to identify internal and external risks, which include financial, legal, regulatory, reputational, competitors, and third-party suppliers, and continually reviews risks the organization faces and procedures in place to reduce risk. Updated legal guidance, such as the DOJ's evaluation of corporate compliance programs, highlights the importance of an independent Chief Ethics and Compliance Officer because DOJ prosecutors, as a threshold matter, evaluates how the compliance program is structured and asks if those charged with day-to-day oversight have adequate authority and stature and sufficient autonomy from management, such as direct access to the Board of Directors or the Board's Audit Committee. Other organizations, such as the International Organization for Economic Cooperation and Development, have provided similar guidance, which states, for ensuring effective internal controls, ethics, and compliance programs, a company needs to give the authority to report matters directly to the independent monitoring bodies, such as internal audit committees of Board of Directors, with an adequate level of autonomy from management, resources, and authority. Additionally, the Chief Ethics and Compliance Officer should not be subordinate to the General Counsel or Chief Financial Officer because freestanding compliance functions help to ensure independent and objective legal reviews and financial analysis of the institution's compliance efforts and activities. By separating the compliance function from the key management positions of General Counsel or Chief Hospital Financial Officer, a system of checks and balances is established to more effectively achieve the goals of the compliance program. The appointment of an independent Chief Ethics and Compliance Officer with direct, unfiltered access to the governing body is not a new issue, as many industries have realized that the modern Chief Compliance Officer requires independence and visible support from the very top of the organization to carry out its difficult and often perilous mission. Since 2003, nearly every healthcare industry settlement agreement has stated unequivocally that the Chief Compliance Officer should not be or be subordinate to the General Counsel or the Chief Financial Officer. After having a corporate monitor appointed in 2017, it appears based on initial results that Volkswagen will have a best practice compliance and ethics program in the auto industry. Volkswagen's potential best practice is due to their new compliance reporting structure and new Together for Integrity program, T4I, which will be used by the board to monitor integrity and compliance. Volkswagen's new compliance reporting structure began in 2017 when Ms. Hiltrud Werner, who is responsible for integrity and legal affairs, was appointed to Volkswagen's Board of Management to oversee the compliance and integrity teams for Volkswagen and its 12 brands. Additionally, in 2017, Volkswagen appointed a new Chief Compliance Officer who will report directly to Ms. Werner. Based on initial results, it appears Volkswagen's new compliance reporting structure has Volkswagen's Board of Management more engaged, as Ms. Werner has noted a shift to 20% of the time during board meetings of the group occupied discussing compliance, integrity, risk management, and business partner due diligence. Additionally, the new compliance reporting structure and T4I program efforts have resulted in a significant improvement in Volkswagen's culture of integrity, as their annual group-wide employee survey, which asks whether it is possible for each individual to act with integrity, has been one of the 3 questions with the highest level of agreement, with a significant improvement in the value. As you can see on the graph, Volkswagen has not completely implemented their T4I program, but does expect to implement the program by 2025 in around 850 group companies in which they hold a majority stake. Based on the 5 principles of the T4I program, which include strategy, risk management, a culture of integrity, a speak-up environment, and resolute accountability, the purpose of the T4I program, which is to give integrity and compliance an equally important strategic and operational priority in their company, as for example sales revenue, profit, product quality, or employee attractiveness, and the 11 key initiatives below that will be measured with board oversight, Volkswagen will not only have an effective compliance program, but will be the best practice in the auto industry. Because the board of directors have the oversight responsibility of the implementation and effectiveness of the compliance and ethics program and reducing the risk to the organization, and an effective compliance and ethics program greatly reduces risk, it would be beneficial for the board of directors to appoint an independent chief ethics and compliance officer to prevent failures in the 3 lines of defense risk management model and to ensure that all employees take compliance and ethics seriously. Additionally, appointing an independent chief ethics compliance officer who reports directly to the board of directors will improve the board of directors' federal sentencing guidelines and Caremark fiduciary oversight responsibilities, because it will increase the likelihood that the board of directors are aware of compliance violations, ensure the board of directors receive timely, independent, and unbiased information, create a more effective compliance and ethics program, improve safety, reduce the possibility of criminal charges, criminal and civil fines, lawsuits, need to have an independent monitor appointed, and harm to reputation. This concludes my brief. Thank you for your time. Does anyone have any questions? You can also send me questions via email at the email address below. Thank you.